Now we go on to question number 5. Again, this is for my assistant. Okay, by the way, she's great assistant. Okay, question number 5. Okay, PR. Yeah, you know that's coming. Okay, so this one is very straightforward. So by the time you get, I'm telling you guys, this is the most straightforward February exam I've ever seen in my life. Seriously. Okay, so here you have to focus on these little facts, what I call the juicy facts. Okay. So I'm not gonna get too much into this because yeah, it was very straightforward. But here they're telling you that Carla's mother is the one that makes the payment. Okay. So is that acceptable? Can you accept payment? Can an attorney accept payments from a third party under the ABA and California rules? The answer is yes. But under both, you're going to have something along the lines that the attorney's judgment cannot be compromised in some way. Let me see if I wrote that down somewhere here. No, I didn't write it down. I didn't write it down. Okay. That's fine if I didn't write it down. But yeah, okay. And here we have to, and also there can't be like substantial interference or any type of interference with the attorney's judgment. But look what it says here based on these facts. It says Larry's services were paid for by Carla's mother. As a condition, I don't like that word right there, of payment for Larry's services, Carla's mother demanded that she be informed of all aspects of the divorce, including Carla's statements to Larry. So then I'm just thinking, wow, like that would be that client there are probably under those conditions. I would not take that client because if they're coming out that strong out of the gate, it's just gonna get worse. So anyway, so at this point I'm thinking, man, okay, so of course the first one is the confidentiality aspect, right? Is that going to compromise the duty of confidentiality that I owe towards my client? Okay. Then the second part here that is there's a little bit more subtle is the potential conflict of interest. I mean, is there a reason why it's a condition? Is there a reason why she's demanding in such a strong manner? I don't know. I'm just saying it's just, and of course, it's just you don't have to hit all these issues, but or maybe confidentiality. But okay, now let's keep going. Because the call of the question is rather broad, right? And what ethical violation? So we're discussing some there. Okay, then it says, let me go ahead and read this because this is going to be important. It says, once Carla's divorce became final, Larry sent Carla a disengagement letter that said he was glad to have represented her. Okay, so I'm thinking, wow. At this point, I'm thinking, man, I'm thinking Larry, he's on top of it. I mean, on top of his I mean, just staying away from liability. Disengagement letters, you guys, are very, very important, especially if you do family law, if you do what's the other one? Criminal law. Because there's going to be some clients there. They're not going to be happy with the result. Even if you did everything right, even if you did everything by the book, they're going to come back and they're going to say, hey, look, I got so many years here. I don't like it. It's your fault. Family law, criminal law. Disengagement letter. Just remember that. Okay. Then it says here, it continues, but also Larry said he would be happy to help her if issues arose in connection with the custody and support order. That sounds pretty standard. Then it says Larry kept Carla's file open because he assumed such issues might arise. Man, family law, visitation, custody issues, that touches into the parents' emotions. I mean, everything here that Larry's doing up to this point, it's great. It's I mean, it's normal. I won't say it's great, but it's normal. It's not out of procedure. Let's continue. It says after Carla's divorce became final. So then we have the after there. Okay, so once it became final, then after the divorce became final. Okay, she and Larry entered into a consensual sexual relationship. Okay, so I think Larry did a great job of 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 not entering into a consensual sexual relationship with the client before that disengagement letter. Okay, or else it would have been a clear violation. It says Larry and Carla have an ongoing dating relationship with and Carla has come to depend on Larry for legal and non-legal advice without pay on tax, child support, and visitation matters. Okay, but again, what I'm saying is just the way I would analyze it. You could say, hey, look, maybe Larry, maybe he is liable for ethical violations because he invited after the representation after the divorce became final. He kept the door open literally, like for other issues that might arise. Okay, and he didn't keep the file open, so that could go either way. Just again, use the facts. Okay, and then let's keep going. It says, let's go ahead and read this. Let's go ahead and read this. Carla's a florist. Okay, great. So that's great that tell she's a florist and wants to start her own business. Okay, so you know that's she doesn't want to practice law in any way. So I mean that would be a huge violation. But for a florist, okay, that's it doesn't violate certain rules. And Carla asked Larry if he would like to go into business with her. Larry proposed a partnership in which he would contribute the startup capital. Carla would run the business and they would split the profits. Okay. Larry said he would like to. Okay, so what are the rules on that? Let me just read this. Larry said uh he said he would draw out the papers and suggest that you can have your mother look at the agreement if you want. Okay, so let's go ahead and just look at the law on that. What does this fall under? Uh, duties with financial duties with a non-attorney, something like that. Let's see, a lawyer should not form a partnership or organization with a non-lawyer if any of the activities of the partnership another organization consists of the practice of law. Okay, so we don't have that. Okay, great. It says here, okay, so when you go into some kind of partnership with the client, that is regulated by the state bar. And that actually appeared in one of the essay questions before February 2006. It says, and this is from the exam. There's California rule 1.81, but in essence, here's what the elements say. It says first the lawyer should advise the other party to consult another lawyer. That's part of the rule, yes, and give him or her time to do so. Give them the opportunity, even if they don't want to seek the counsel of a non-interested lawyer. Second, the lawyer must disclose and explain all of the relevant terms of the contract in a way that the other party can understand. Last, the terms of the contract must be fair. Okay, so fairness. So I think if you mentioned two elements, if you mention fairness and maybe the opportunity for the non-lawyer to consult a lawyer, I think you're fine. But again, this is very straightforward. This question is very straightforward. Okay, so I think yeah, again, I think they made it straightforward intentionally. So that should be to the advantage of most bar candidates. Whereas the MBE was more like throw it out there and see what happens. And right, from my understanding, there was a lot of unexpected and unwanted results from that. But who knows? We'll see what happens on May 2nd, when the test results are released. Okay. So with that said, does anyone have any questions, comments, concerns? No. Okay, great. So let me go ahead and I'm gonna stop sharing. Okay, so thank you everybody. I wish everyone the best of luck here. I hope everyone here that is watching, I hope you guys passed. And I look forward to calling you guys my colleague. And I'll see you guys in the tribunals and in the court halls here soon. Okay. No, not a problem. My pleasure. Thank you very much, everybody. And I wish you a wonderful day. Over and out.